Good afternoon. It's my honor and privilege to welcome you to the weekly Saturday Solutions, as we call it, the BW Legal World and BW Business World webinar on issues that impact all of us and are at the intersection of business and economy, are in the intersection of legal with business and economy. Today we have a very high-powered and stellar panel to discuss the rising issue of white-collar crimes, and we'll broadly discuss what are these white-collar crimes, are we as business professionals or legal professionals, and the framework to govern that, keeping pace with the creativity of people who are perpetuating these crimes. We'll also ask how are white-collar able criminals able to get creative with these crimes, what are the loopholes they exploit. We'll also talk about some specific instances. We'll talk about digital economy and the fact that the economy and business have morphed in the last few years, presenting new challenges and opportunities for people who commit the crimes and challenges for people who are trying to make sure that these crimes don't happen or bring the perpetrators to book. Let me introduce our very, very esteemed panel. It is truly esteemed in the true sense of it, practitioners who understand these, stakeholders who are deeply into solving these or providing solutions to these. We are live on bwlegalworld.com. We are live on businessworld.in. We are live on the homepage of Businessworld, on the LinkedIn page of Businessworld, and on our Instagram page and our Twitter page. Let me introduce, these are people who really don't need an introduction, either in the business community or the legal community. But as is customary, to put a context, let me formally introduce all the 5 guests on the show today. We have Justice Mukta Gupta. Her judgeship is very well known. And thank you, Justice Mukta Gupta, for joining. She's a judge in the Delhi High Court. And your being here adds gravitas and a lot of seriousness to our discussion. Thank you for making time today. We also have Mrs. Pinky Anand, again, who doesn't really need an introduction. She's a senior advocate. She's a former ASG, and she's very, very active even today, not only in her practice, but in social issues that impact the country. Thank you, Mrs. Pinky Anand, for joining us. We also have Mr. Pramod Dubey, again, very well known, and he's recently been appointed a senior advocate. So welcome, Mr. Pramod Dubey. We also have Mr. Vaibhav Gaggar. Vaibhav is our senior partner in Gaggar and Associates, and again understands the contours of white-collar crime and issues that face contemporary times. And clearly, I must say, Vaibhav doesn't only do white-collar crime. Of course, like a lot of law firms, the last 5 years there have been a lot about insolvency and NCLT and NCLAT. There's a lot of work in that area. Last but not the least, we have Mr. Anupam Sharma, who's again an advocate, and he's a special public prosecutor with the CBI. And we welcome his joining us. So let me start by asking each of the panelists their opening comments on the rise of white-collar crimes and what should be done to tackle them, and has the law kept pace with the creativity of the white-collar crime. Let me start by inviting her judgeship, Justice Mukta Gupta, for her opening comments.
Good morning, everyone. Thanks for the invitation. It's a pleasure being here and being a part of this August gathering and sharing my views. Let me first of all start with saying that when we say white-collar crimes, it's an evolving or it's a starting concept. I think to my mind, it is completely wrong. It was not even recognized by the Santhanam Committee. It was actually ingrained in our Indian Penal Code, which goes back to 1860. It recognizes that Indian Penal Code recognizes all financial crimes, breach of trust, forgery, counterfeiting. What we are seeing is today, by way of digitalization, global economies, these crimes and the methods to commit these crimes are evolving. And since those crimes are evolving, we have to keep pace with them. And that is why we keep amending the provisions. We keep bringing new enactments. Now, Income Tax Act 1922 provided with the prosecution and penalties. Then there were if you see the IPC, it has all, it punishes bribery, corruption, then food adulteration, counterfeiting. Then FERA was a known offense. There were provisions for it even before Santhanam committee recognized all this. And that is why in the 29th report of the Law Commission, when the issue was flagged by Santhanam committee, which said we should consider having laws or adding in the code offenses calculated to prevent and obstruct the economic development of the country and which endanger its economic health. The commission felt that it was a very, very widely worded report, and some of the suggestions were already incorporated in the IPC or various enactments, and some was beyond which could be added in that. But as law developed, we've had special enactments as per the requirement of the society. In fact, what is law? Law is an answer to what is the societal requirement for justice. And as and when we see that a particular kind of crime is growing, additions are made, amendments are carried out to the provisions, then procedural aspects are added. And to that, we further add new new acts if required. Now, if you see, IPC have all these basic offenses. But now, as we have grown, we've found that Income Tax added needed amendment. The Companies Act needed amendment. More so by virtue of Companies Act, the manner in which corporate offenses were being committed, it was felt that there is a specialized investigation which is required, and then came the concept of SFIO to investigate those crimes. So it's always an evolving concept, and I feel that we have always grown up with, as the crime increases, the amendments, acts, and the procedures help us in tackling all.
Thank you, Justiceship, for your opening comment. And you are right that clearly there have been specific interventions by policymakers, like you talked about SFIU, to be able to deal with the evolving nature of these white-collar crimes. And yes, at some point, I would like to make a distinction between the crimes committed by corporates or individuals in corporates against the government or the banks, versus the white-collar crimes like phishing, cybercrime against individuals by organized groups of white-collar crime professionals or thieves, as I would like to call them. At this point, let me bring in Ms. Pinky Anand, who's a senior advocate. As I said, she's a former ASG, and she has a nuanced viewpoint on this. Ms. Anand, all yours.
Thank you so much, Anurag, and thank you, Justice Gupta, for starting the way forward and to put the issue in perspective. And you are right. I mean, ultimately, crime is old, and so is the law in its own way old, which has been coping from time to time by way of amendments. And I think that is the message that you've sent forth. Anurag, I do think the current context of white-collar crimes, I mean, it changes from, by the way, from few months to few months. The current context possibly is Mehul Choksi's arrest in Dominica is something which started the ball rolling on this discussion and bringing it to the current situation. And I think our extradition law is also something which needs to be put into perspective here, because the financial acts to bring back interlopers, if you call them, or you call them thieves, whichever expression is used for such a white-collar crime, I think this is one of the strongest points that we need to be grappling with. I mean, even now we have Nirav Modi, who's filed an appeal in the UK courts. Of course, it's his right. But nonetheless, he's filed an appeal and he is staying put in England. And as far as Mehul Choksi is concerned, is being protected for the time being by an order of the Dominica court, which is passed an interim order, which restrains us from getting him back. Because this is one of the forerunners of our issue. We need to have people back in the country to be able to not only prosecute them, but also bring the ill-gotten gains back to the people who have been duped. But having said this, I must say, I find a very interesting comment on white-collar crimes by the sociologist Edwin Harden Sutherland, who in 1939, as Justice Gupta rightly said, 1860 is the Indian Penal Code, and this goes back to 1939 definition, defines it as crimes committed by people who enjoy high social status, great repute, and responsibility in their occupation. Added to that, the technological part of it, which puts things into its own perspective as far as white collar crimes are concerned. So the 5 attributes according to Edwin, it is a crime as much as any other crime in the IPCS. It is committed by an important person in the company who enjoys a high social status in the society, and that gives him the margin to be able to perpetrate these white collar crimes, because there is an element of initial trust, though ultimately that is shown to be otherwise. I mean, I've seen several examples. For example, the National Spot Exchange, which led it to a total electronic exchange and setting up of the entire exchange, which duped people of about crores and crores, as each of them is. By the way, each of these white collar crimes has a high rate, a high income issue, a high loss to society. So coming back to the definitional part of it, it commits this in the course of his profession or occupation. And there is, of course, a violation of trust. This is the element I was talking about. These high people basically invoke trust from people. Because of the trust, people go into this situation and ultimately are duped of these huge losses that occur to them as a consequence of this. These are normally non-violent. I mean, that's a funny part of it. Like, there is no chura and there is no blood. So there is no murder and there is no active taking away of an actual asset from a person. It is ultimately a non-violent crime committed behind the scene with so many things. Take the PNB scam, for example. You have the letter of undertaking, which is the principal mode of financial transaction. Principally, these are financial or cyber crimes as a broad concept as they come across. Now, the 3 features of white collar crimes: corruption, fraud, bribery. Now, bribery, as I'm going back into what Justice Mukta Gupta said, that the Prevention of Corruption Act, for example, is already there. And incidentally, while we talk about it, today, the recent amendment in the Companies Act has actually said that crimes that are covered in other acts will not be covered within the purview of the Companies Act. I'll come to that later in a question that we might be discussing. But these are the prime: corruption, fraud, bribery, which changes the complete dynamics of the white collar crime. The CBI, we have Anupam here, who will be deposing, if I might say so, but or rather stating later. But the CBI itself actually had, in the last 10 years, a total of about 6,533 cases of corruption. Out of them, 517 were registered in the past 2 years. I mean, these are the kind of numbers that we're talking about. 4,000 crores of trading in fake or duplicate PAN cards. As you were saying, what are these crimes? Fake and duplicate PAN cards. Maharashtra showed the most rapid increase of about 999 cases being registered. There are also about 3.2 million people who suffered loss because of stealing of their card details reports, which was administered by Hitachi Payment Services. So advancement in commerce and technology has invited this unprecedented growth in one of the types of white collar crimes known as cybercrime. That is the other type, which is increasing because there is very little risk of being caught or apprehended. Transparency International Corruption Index, Annurag, has actually had a variable. If you see it go, it was high, it went down, and again, in 2020, it has come up to about 86. So it grows across surface, and of course, I can't say what the attribution of COVID is, but net result of this, what is the net result of these white collar crimes, whether it is Colgate, whether it is 2G scam, whether it is the National Stock Exchange scam, whether it is a Satyam scam, whether it is a property scam, and each of them involves huge amount of losses. It's a huge loss to society. It causes an escalation of costing price and products. It results in lowering of salaries and jobs. It results in an adverse effect on the economy. So you have basically a pullback of the economy. You have loss of confidence. That is one of the principal problems with these kind of scams. There's a loss of confidence in transactions, and particularly financial and other such transactions which are involved. Elderly people are very easy targets. The gullible people, so to say, who ultimately get taken in by all these assurances and move into these spheres, ultimately taking them away. So this is the broad circumference, Anurag, of the entire white collar crime. And we have a system. We'll to speak about more of it, but Justice Gupta has already laid out the broad profile of what it would be. Some details I'd like to share with you later, but we'll do that in a later part.
Thank you so much, Pinky Anand, for giving your very nuanced viewpoint and bringing context as well as the current development into focus. Let me now bring in Mr. Pramod Dubey, the senior advocate. Mr. Dubey, your opening comments. You've been on the representing some of these people and you've seen all spectrums of white collar crimes. So your perspective would be very, very important. We request you to unmute yourself. Yes.
Good afternoon to everyone, and I would like to pay my regard to all panelists, Justice Ms. Mukta Gupta, Ms. Pinky Anand, my dear friend Anupam Sharma, and my dearest Mr. Vaibhav Gaggar, and thanks to Dr. Anurag Batra, who has provided us the opportunity to interact with all of you. First, I would like to say it has rightly been pointed out by Justice Gupta. The white collar crime, the offenses, the main offenses which are already enacted in the Indian Penal Code. As per the time when the demand the demands started coming from the society, so we started the enacting the law. And you will find that, as mentioned by Ms. Pinky Anand, we are going through this Mehul Chaksi. I would say when I joined the bar, there was a big scam, that's a white collar scam known as Harshad Mehta scam, which damaged the entire economy of this country. Then Hiten Dalal case, then the Ketan Pari case. So there are so many things. And you see the big bank fraud like the Nirav Modi case, Vijay Mallya case. So this white collar crime is not being committed by a normal people. It is committed by a people which have the not, I would say, not the normal brain skill. They have the abnormal and the very fast brain skill, and they commit this kind of the crime in well planned manner, so that the people will, and even the investigating agency would be confused about their modus operandi, their act of the commission of the offenses. So this is very intelligent mind which are involved in the commission of the crime. That's why the word which has been mentioned by just Ms. Pinky Anand, Edwin Sutherland, which coined this word in 1914, because your collar is white, but your act is not white, which is unlike to the blue collar crime. The blue collar crime is related to your person. You are committing the injury to the person. This white collar crime is related to the commission against the property. It's basically the financial crime. And there are so many types of the white collar crime, like the banking fraud, blackmailing the individuals, bribery, the computer fraud, which is very, these days is a very common to commit the offense, like the embezzlement, extortion. And one interesting thing is the inside trading. Inside trading, the share scam. You must have noticed there are so many scams coming in the SEBI matters. So SEBI is also one of the money laundering. The money laundering is the classical case of this white collar crime, because you have committed the schedule offenses. Now you have laundered the money, and layer by layer, you are diverting the money, so that the investigating agency or any person will not reach to the root of your act. And this is the tax fraud, and the tax fraud is going so high. That's why the legislature will compel to amendment, and then they give the more power to the SFIO to conduct the investigation. So this kind of the investigation, the crime is going up. And you see very interesting thing, the way the white collar crime is going on. There is a very interesting film just as released, where the Abhishek Bachchan has acted the big bull. It's very popular in the business society and the legal society also. So these kind of the offenses, the white collar crime, and needs to be taken very minutely with the good law, and we have the law. So we are every day we are moving forward to check this kind of the crime. Thank you so much.
We'll get into the details of what you said, Mr. Dubey, and the nuances that separate us, one crime from another crime. I also want to share with our audience that Ms. Anisha Aditya, who's an editorial colleague at PW Businessworld, will also be with us, and so will be Mr. Krishnendra Joshi in asking questions. At some stage during the conversation, I will bring them in. But at this stage, let me bring in Mr. Vaibhav Gaggar. Mr. Gaggar, your opening comments.
At the outset, thank you for having me on this very august panel. And thank you, Justice Gupta, Ms. Anand, Mr. Dubey, and Mr. Sharma for laying the ground here. To start on a lighter note, I suddenly realized I'm wearing a white collar shirt, while some of my friends here have the blue collar shirt. And that's where I don't think a distinction between white and blue should be gone into on a purely personal note here. But I think it's very important to understand one thing, of course, as laid down already by my esteemed panelists, that white collar as a concept has been there prevalent for a very long time. The first time, in fact, it was reported was 1473 in the UK, where theft was taken to be a white collar crime, and a person who was supposed to transport goods was therefore trusted with the goods, and he took away from it. That's where it started getting reported, at least legally speaking, from what I've understood. Be that as it may, today the nuances of this are very different. The IPC offenses will always be the underground or the underlying factor. Fraud, forgery, they will be the essence of it. We've touched upon cyber crimes, we've touched upon insider trading, we've touched upon money laundering. But we must understand one thing, and this is something in my limited experience that I've noticed. Until and unless the prosecution, as well as the fraternity dealing with it, really understands numbers, really understands the mindset of the person who's playing this. Because as we've established, as Ms. Anand also put it, it is, since 38, Sutherland has said, it is the higher intelligence, if one may call it, right? The people who are at a particular status, they are the ones who are playing these games. They're the ones who are manipulating this. Until and unless you're able to decipher this, break the numbers, you will always be lost. And while we have a lot of cases being reported, till date, we've had less than 17 convictions under the Money Laundering Act. That's a statistic that was a bit shocking for me. If that be the case, how are we deciphering this? The Harshad Mehta scam or the Hiten Dalal scam, because they reached such gigantic proportions, people really looked into it. But insider trading in India is 1/nth in terms of reporting versus the global standards. And insider trading is perhaps one of the biggest frauds that happens in India, and it kills the stock market. I tried to dabble in the stock market a bit, and I realized I have no idea what seems to be logical. Somewhere the demand is going up, the price is falling, and the converse is happening. Economy just doesn't make sense at times. And until and unless we're looking into it with a very sharp eye, with people who are trained to look into it, with deep forensics that happen, and it is not going to be possible for all lawyers to be able to do it. You really need some expertise to be able to get into it, brief the lawyers, get them up to speed with it to be able to tackle it so that the courts can really step in. Today, with greatest respect, we are dealing at a 30,000 level with most of these cases, unfortunately. They become voluminous. People lose sight of what the real issue is, and these people are able to then move one layer to another layer, and it becomes almost impossible to uncover the same. So white collar crime is a very wide concept. Just under the PMLA, that's the Money Laundering Act, you've got more than 24 scheduled acts which would come into play. You've got more than 300 sections which would automatically attract the Money Laundering Act, right? Until and unless there is specialization and understanding of commerce, math, accountancy, forensics, I think we're still some time away from being able to really tackle the menace of white collar. And we are not even getting into the cyber frauds, artificial intelligence, crypto frauds, and what I like to call the new age frauds or the new age white collar crimes. Those are another menace by themselves. So it'll be interesting to see how the jurisprudence evolves there.
Thank you so much, Vaibhav. I must showcase that I'm neither wearing a blue collar or a white collar shirt. I have a green collar shirt, if it just to be specific. But thank you for bringing that humor, and thank you for bringing the perspective. Last but not the least, we have Mr. Anupam Sharma, who's an advocate and is a special prosecutor with the CBI, to make his opening comment. And I have some specific questions for him. I'll start with him in the second round again. Mr. Anupam Sharma.
Hello, pleasure to be here. The very concept of classification of white collar crime and blue collar crime itself is flawed. Now, the moment we term these criminals, the economic offenders, as white collar criminals, they are treated with a kid glove. Why I say this is in Indian Penal Code and other provisions as well, the maximum punishment provided for most of the offenses is either 7 years or less than that. And there are also provisions wherein they can get away by payment of fine, or they can compound the offenses, which should not be there. Take, for instance, the blue-collared crimes. What is the punishment? The highest levels of punishment possible for them. And these are the persons who are actually committing the crime against the society, These are the actual persons who are committing crime against the country itself. Now, having said that, why is it going to this proportion is something that we all have to understand. There are loopholes which they have been using, and through those loopholes, the crime that is being committed is increasing day by day. Let me take a small example. Now, examples are so many. A very small example. In criminal jurisprudence, there is a principle of vicarious liability. That does not apply to criminal law. If it does not apply to criminal law, if a person has to be has to be prosecuted, for that purpose, we have to prove his intent and also his active involvement in the offense, which is not possible. The only reason for not being possible is because these multinational companies and these companies are controlled by their family controlled companies. Although they are MD, they are CMD, but whatever happens is behind the doors of the office, and nobody can dare give statement against them, and they do not convey their decisions in black and white. The result is the prosecution would never be able to prove that that the offense was committed by this MD, and that since they can't be vicariously liable for it, therefore they can't be prosecuted at all. We have so many cases. 2G case is an example. All the accused who were actual owners of the companies, who they all got off, either they were discharged or they were not prosecuted at all. We need to change the law. We need to have a presumption against these persons. We need to have a law wherein there should be a statutory we should have a statute wherein they should be vicariously liable for the acts of the companies. After all, they are the will of the company. They are the command of the company. Having said that, we have created layers and layers. Now we blame prosecution for everything. I just heard my friend saying that we can't move up the ladder as fast as they do, but that's not true. We have layers and layers of hurdles before we can even actually register an FIR. One thing I like to point out: now the Central Vigilance Commission has passed an order that there shall be a committee for what is it called? Yes, for the crimes, for the fraudulent crimes. Now this advisory committee, if there's an offense which has been committed by a general manager of a nationalist bank and above, and if the fraud is of 50 crores or more, it has to be reported to the advisory board. The advisory board thereafter would decide whether the complaint should be lodged or not. That does not end here. Before that, the moment the fraud is detected in a bank case, they'll start firstly, it is very tough to detect. It takes years because there's an insider who is involved. After years it is detected, we'll have another person, they conduct the forensic audit, which will again take years. Now, once the forensic audit is completed, thereafter they'll send it to advisory board for their recommendation. Once it is given, it will come to the police. Now we have 17A amendment of PC Act, and as per 17A of PC Act, we can't register an FIR, we can't start an inquiry, we can't start any investigation in a case until unless we seek approval from the appropriate authority. Now that will again take, and at times it has so happened, and it is in so many cases, that the approval authority is himself against whom we want to investigate. What to do in that matter? He becomes a judge of his own cause. Now, having said that, once these hurdles are cleared, then because of in the meantime, 6 years would pass by for international banks. Now, these are the practical problems. Now, 6 years would pass by. International bank says, now we don't keep the record. We have all destroyed the record. We won't get the record. To get the records, we have to get issued LRs from the court, and the other country would have take its own free time. So there are so many hurdles. Even if we complete the investigation, the accused would abscond. 200% accused have absconded abroad, and we are spending tons and tons of money of public exchequer to bring them back. Litigation. And besides that, what is most important is the moment we complete the investigation, then again we'll have to go. This is the third layer, the third hurdle. We'll have to go before the competent authority for the sanction. Now, this is not only it. At every stage, now it is a time that we should have changes in the law. In a manner, they were speaking of the Companies Act. Let me tell you, here also in Companies Act, to make a person an accused, we have to prove the intent. Even under section of 10 PC Act, we have to prove that he had consented to the offense. Now, these are the things, because it is taking in the four corners, it can't be proved. For other offenses, we have presumption. Here also, we should have a presumption against the persons who are in charge of day-to-day commission of the work of the company, so that they can be held responsible. It is only then. There's no other way. It is only till the time we don't bring those big names as an accused. Till then, this crime would continue unabated and it will increase. It is only then, once they are made an accused, once we have amendments in the provisions, only then it is possible. Otherwise, it will keep on increasing. Thank you.
Thank you so much, Mr. Sharma. You already brought in the element of multiple agencies, multiple approvals, delays, and so on and so forth. I was going to ask you in the second round, but let me bring in first Mr. Pramod Dubey into the conversation again. Mr. Dubey, again, you are again a veteran of this domain. I want to start by asking you, can you give us an overview of the legislation dealing in white-collar crimes in India? And are there any caveats which you have identified in these legislations? Please let us know that what are the reforms or upgradation, if I may use the word, needed to keep the legal framework even more contextual and latest in terms of dealing with the white-collar crimes that we've discussed. Mr. Pramod Dubey.
Thank you, Dr. Batra. Batra, we have the certain legislation pertaining to dealing with this white-collar crime. As it has already been discussed, the parent act is IPC and the Companies Act. So we have the Companies Act. There is amendment in the Companies Act. They have put the stringent condition in the Companies Act for the bail. Then the power given to the SFIO, and SFIO is doing their job these days. Then the Income Tax Act, and they have also brought the Benami Transaction Act. Then the Indian Penal Act, there is an amendment in the Indian Penal Act, the Commodities Act, and earlier there was a provision in the IPC for the commission of the crime by the public servant. That's popularly known as the Corruption Act. So there is a special act, there's a Prevention of Corruption Act. Then the Negotiable Instrument Act is also there, and the Prevention of Money Laundering Act 2002. And there is a lot of amendment going on in this money laundering act. As rightly pointed out by Justice Gupta, it's a law evolves as per the demand of the society. The society's demand is there, and they are making the amendment. The legislature are already working on day to day. Then the Imports and Exports Act. So these all are there. The SEBI Act. There is also amendment in the SEBI Act. So these are the legislation for dealing with all this the white collar crime. So far as the notable caveats are concerned, of course, there is a caveat like the sanction under Section 19 of the Prevention of Corruption Act and 197. But you have to balance the right of the accused and the right of the society and the prosecution. So you are giving the right to the person who are proposed to be an accused and the public servant. So first you satisfy and go to the hurdle of getting the sanction. It is necessary to get the sanction because sometimes we have seen there is an abuse of the process of the law. So this is also the caveat. The second is very important. There is a commission of the schedule offense for the Prevention of Corruption Act. So these are the caveats. So far as the reforms are concerned, so there is a lot of things are going on the reform, like the plea bargaining, the introduction of the plea bargaining, then the faster recovery of the money and loss to the exchequer. As it has just mentioned by Mr. Anupam Sharma, there is a government exchequer, loss of the exchequer, so many things. For that, I would like to mention here, there is a judgment of our own High Court, Delhi High Court, Sunny versus the state. And the Sunny versus state, the Delhi High Court has already passed the guidelines for the compensation and for the exchequer to the government and the expenses incurred towards the litigations, investigations, so many things. So I think there is also the provision, and moreover, we have the provision under 357 CRPC for the compensation to the victim, the affected party. So we have the provision. the very important thing is the speedy disposal of the cases, which is not going to be possible in the near future due to ongoing pandemic, because you have already seen the system is not working. It is almost collapsed. We are lucky that we are practicing in Delhi High Court and we have good infrastructure. So we are working our high courts and the lower judicial officer, they all are working. So it is not like that there's the pendency, but there's a lot of pendency in the cases, especially in the white collar crime. And the problem coming in the white collar crime, the investigating agency, they are making a lot of people as an accused, lot of people as witnesses. They are filing the voluminous document. So it takes a lot of time in the scrutiny of the document, supply of the document. They are not coming forward. They see there the certain instances where the documents are favoring is to the accused. The documents are exculpatory in the nature, but they are deliberately hiding the document. They are not relying on the document. There is only mark by the investigating agency. These are the unrelied upon documents. Then we are approaching the court. Then we are going to the High Court, then the Supreme Court. So it's consuming lots of effort. So it is also incumbent for the prosecuting agency to file all the documents and supply to the accused. Let the accused decide whether he is relying on those documents or not. So a speedy trial is very, very important. And then enable the state to unearth the full conspiracy, because the white collar crimes, the genesis of the white collar crime is the well-planned conspiracy. It cannot be done by one person. It can be done by two persons or more than two persons. So there must be the conspiracy, and you have to adopt the methodology, because you see these days the lot of the cases which are not only based in this country, it's international offenses also. The money being layered from the one country to another country, they have committed. Then they have flew from the justice this territory, Indian territory. They have already gone abroad, so they are issuing the laterogatory. There's so many things, but we can go ahead by making some more amendment in this all these things and expedite all these things. So these are the things. And then the more important thing, as it was just mentioned by Mr. Sharma, is the maximum punishment is 7 years and the less than the 7 years. See, the punishing the person, putting behind the bar the person in the, especially in the white collar crime, is not the sole purpose. That could be the deterrence, one way of the deterrence. But the thing is, you have caused loss to the exchequer. So there must be the recovery of the money. And we have the certain provision in some special acts like the PMLA and SFIU, especially in the PMLA for the attachment of the property. So it should be encouraged. The penalty should be there in the proximity of in proportion to the commission of the crime. Suppose you have committed the crime of the 1,000 crore rupees. So there must be the provision to put the penalty upon you, so that the government exchequer should not suffer for all these things. So you have to also increase the civil remedy also, and the compounding, I would say, yes, compounding must be encouraged, because the compounding, if you are compounding the offenses which are the white collar crime, so you are compensating the victim, because you cannot go with the sole purpose of putting the person behind the bar. You have to just give the message to the person, yes, you have violated the rule of the society, rule of the law. That's
use it as a preventive. Use,
yes.
Use the financial impact, because if there is a white collar crime or a business bank, financial impact can be a bigger deterrent in future than just the.
I would like to advocate for this. Yes, there must be the heavy financial penalty on the wrongdoers, so that there should be a compensation of all these things. So these are basically the reforms, and the SEBI also. These all are these, and also as pointed out Mr. Sharma, because Mr. Sharma is a special prosecutor, CBI, so he has a lot of experience. But you also need to organize your internal institution and give the maximum facility to an investigating agency so that they can come to the terminate the investigation, go to the court of law in a very fast manner. So infrastructures are also required, and there must be the enforcement of the law. We have the ample law. It is not like that our country is suffering from the lack of the law. We have the provision, but you have to make the enforcement agency stronger and stronger every day. So these are the basically the reforms you can adopt for the minimizing the commission of the white collar crime.
Thank you, Mr. Dubey. Let me get in my editorial colleague, Ms. Anisha Aditya. She'd like to start by taking some audience questions and then ask a set of her questions. There is a question from Shashank Devan. Anisha, you might want to take it to all the panelists. Start with Ms. Pinky Anand and then go around the house to Justice Mukta Gupta, Mr. Sharma, and Mr. Gaggar. Anisha, all yours.
Surely. Thank you so much, Dr. Batra. We have a question from the audience on the legislations governing white-collar crimes in India. The audience here mentions that there is a wide consensus that most white-collar offenses under IPC, but then the purpose of introducing special legislations for similar offenses become redundant. Does the same offense, which is being governed by two legislations, for example, does the fraud coming under Companies Act and also coming under IPC create confusion and difficulty in its prosecution and thereby the jurisdiction of such a matter?
Thank you, Anisha. If that is addressed to me, I think it is, as Dr. Annurag led the way. There is indeed a big dichotomy in law in this part. And Shashank has rightly raised the question of having, let us say, double jeopardy. It's not double jeopardy technically because there are two laws and they ultimately deal, and who knows which law would prevail and which should be exercised. But there is one other aspect that I want to point out, and I think that's important. What happens at times is, and we've noticed this across legislation and law in various fields, not only in white-collar crimes, in general laws also. There are crimes which are identified and recognized under the IPC, but one way or the other, they don't fall within the domain. Just to give an example, it's like dowry debts. Dowry debts was classified as a separate offense under 304B. When 302 was already there, murder was already there. Whether you needed that particular classification, but sometimes when you find the ingredients of these offenses are such that they require a special treatment, it is that time that you either A, reclassify them and have that classification, or B, you want to focus more attention because the economy today is having such an adverse impact based on these white-collar crimes that you need to bring attention. It's like you're having the webinar on this context because it is something which is of significance. So therefore, attributing that, I think this is one of those domains which need to be thought about. But at the same time, I do believe that, there's another way of doing these things. You can amend the laws which are existing. So you have this paraphernalia of laws. But even today in Companies Act, as I think Pramodji pointed out quite rightly, there have been changes from time to time at every time. Every time grappling with the new situation, financial transactions, conspiracy. Conspiracy is there in IPC by all means, and most of the crimes, whether they are white collar or they are even the Jain murder case, whichever they are, conspiracy has been there since yesteryears. So you have the element of conspiracy, but the financial aspect of it and the manner in which it is dealt. Another aspect, for example, freezing of assets of the offenders as one of the principal remedies, not only putting them behind bars, you have to put them behind bars by all means, but in addition, not only to recover the money, but to put a penalty which is prohibitive. To give you a small example, take traffic fines. When traffic fines were 100 rupees and that kind of amount, nobody bothered about them. And the situation went on. I'm not saying it is even today something which is the manner in which it should be, but there is a wide difference now. For 2,000 rupees fine on mobile talking makes by itself a major difference to people. So you can imagine if you multiply that into millions and trillions and crores, what the kind of impact would be if somebody's assets are at stake. The third aspect, I think, which requires, for example, you have the Fugitive Offenders Act. I'm just pointing out how you try to bring law in tune with what is happening. The Fugitive Offenders Act was principally brought in to curb this fleeing away from justice. Because what do you do when a person is not here, nor has assets here? They've been already frittered away from people. In turn, there's further frittering away from India to Dominica to UK or wherever that might be. So the tracing of that entire process is something that requires definitely special treatment, though you have an Extradition Act which is already in place, not that you don't have it. So these are the elements that you have to work with. And yes, at times, not only the new crime, the new dimensions of the crime, and the new creativity, as Anurag rightly said, the new creativity of criminals, to bring that into focus, you to deal with it, you do need to sometimes bring in a new law to cope with it as much as to amend it. So another part I would just say, and I would, rest it there for the time being, you actually had the Companies Act 2013 amendments. Now, they dealt in all those conspiratorial parts. For example, interested directors, related party transactions, how you're related, and that insider trading that Vaibhav was talking about. So how do you actually get to it? It is again something known earlier, but the manner in which you get to, so the identification of those classifications. In fact, 2013 Act, to my mind, of the Companies Act and the amendments, brought in a totally different circumference. Responsibility, the corporate responsibility came in 2013 amendments. It was there, but identified. And I think that's which started the ball rolling into quite another direction, as much as the SFIO, which I think has done a tremendous job and needs a little more teeth to, in fact, get into the situation. Multiple investigative agencies is always an asset as much as a liability. So, for example, ILFS, you have about 7 investigative agencies participating in the scam who are taking action there, which is sometimes considered a very good feature that so many agencies are. But believe me, good or bad, these create their own dimensions and their own circumferences, which are so often difficult to grapple with. They're a delight for people like Pramod Dubey, lawyers who appear for such white-collar crime people, because then they can get away with far more. But having said that, I mean, these are the traverses. So we are grappling with new dimensions and adapting ourselves in law as much as social impact consequence, as much as even CSR and corporate responsibility.
Thank you so much. I'd like to bring in Justice Mukta Gupta into the conversation. We've talked about that there shouldn't be no difference between blue-collar crime and white-collar crime. It was laid down by the Supreme Court of India in the case of State of Gujarat versus Mohanlal, Jita Malji, Porwar, and respondents. The judgment mentioned that causing financial loss or committing economic offenses requires planning, calculation, and an extensive strategy to derive personal profits and benefits. What is your thought on this, and how would you differentiate white-collar crimes compared to other traditional crimes? And I said right up front, Justice Mukta, that, again, there is people like Nirav Modi doing crimes, and there may be a organized gang of petty criminals who may be doing what I call phishing. It happened with a partner's wife. Someone took her number, and from that number transferred monies. So those are also, that is happening to a large number of people, and hence the impact is huge. So should there be a classification? Should there be no classification? And this classification should end.
Thank you, Mr. Batra. See, as Justice Thakkar put in the judgment, State versus Gujarat versus Mohanlal, Jitam Lalji Parwal, he noted the distinction between a general crime and a white-collar crime. He says a murder can be committed in the heat of the moment, but these economic offenses are committed with a cool manipulation, calculation, and a planned strategy to gain personal profits. And that is the crux of the matter. Now, what happens is that when we say white-collar crime, one of the ingredients is it's by high status. It may have been defined when it started with people doing with high status, and that's why when we say white-collar crime, we get all these big names into it. But if you see, as Mr. Gaggar, Mr. Anupam and Mr. Dubey had put up, that the ambit has gone so wide that people who may not have a very high status but are involved in, as you said, phishing is one of the crimes. He may be a petty theft, involving petty theft, but the repercussions are very high. Now today, see, multiple people today, these days you're getting of having fake call centers, hacking your numbers, phone numbers, and then asking your OTPs, and then your bank accounts are. Today in courts, we are virtually getting every day and these kinds of matters. Now, this may not be done by people who are high in society, but they are having a very big, serious impact on the society. No, See, a general crime and this so-called white collar crime, which is actually more prevalent at the moment, has a totally different approach. What has happens is in the general crime, the victim is identified, the impact is immediate. So the report gets lodged, investigation is conducted, and there is no delay in trial and investigation. But the problem arises in this: the victim is not individual, it's a society at large or a large number of victims. By the time it is realized that an offense is committed, it is too late in the day. Most of the evidence is lost. As he said, after 1 year, you cannot even have the CDRs. You will not get the bank accounts because there is a life to retain them. By the time it is unearthed that this income tax violation has taken place, much of the documents are lost. Similarly, when now PMLA, which came up as a specialized offense, it does not it does not convict you for the offense committed. It commits you for the proceeds of the crime of the offense. So you have simultaneously one agency like the CBI investigating into the offense and trying that, and you have PMLA, which is looking into the proceeds of the crime. But that proceeds of a crime is subsequent to the offense committed. Now, most of the time, issues which arise is that, look, the CBI has not even filed the charge sheet. Where is a prima facie case that I have committed a predicate offense? If I have committed a predicate offense, then only you will come to the conclusion that this amount with me, this money with me, is a proceed of that crime, because PMLA's scope is only with regard to the proceeds of the crime.
Yes.
So whether it falls in within that scheduled offense or not. Now, similarly, not to tackle with this, yes, various enactments have been brought. The approach is taken totally different. You need very, very highly sophisticated and specialized agencies, not only to investigate, but at the stage of trial also, you need to train the advocates who can then put up the correct facts before the court, and you need to train the judges also to understand that aspect, which is pointed out by my earlier predecessors. I'll just give one example in this regard is, see, to overcome all these problems, as you pointed out, the question which we were answering was that fraud is punishable in IPC, plus it is also in the Companies Act or associated with other offenses. Now, whether there'll be an overlap. See, to overcome this problem of specialized offenses, what you will find in that in most of this enactment, either the mens rea, the intention part, has been taken away. These have become strict liability offenses, because it is very difficult for the investigating agency and the prosecution to prove that the accused did it with the intention to do it, which is necessary when you are dealing with the offense of fraud under IPC. Now, or they have put in a column of provision of presumption. Now, once the presumption is to be raised, it's a reverse situation where accused, who has to be silent as not to say anything, the prosecution has to prove beyond reasonable doubt, has the onus to discharge that, look, I have not committed this offense. So, which can't be proved in the positive by the prosecution, they are then bound to prove in the negative that no, I have not done. So these provisions have been added to overcome all these difficulties, and that is why I started with the fundamental aspect that as crime evolves, as the societal demand evolves, so does the law, and every enactment brings with it its nuances, its new amendments, and coupled with the problems of multiplying cases in the courts, multiplying specialized investigations, overlap of offenses, but then that is the society's requirement and we'll have to deal with it.
Thank you so much, Mr. Dubey. You were quick point from you because you were raising your hand, and there are two audience questions that we'll take quick.
The question came for the double jeopardy the punishment of in the Indian Penal Code and the Special Act. Here, I would like to mention we have the provision in the CRPC section 4 and 5. The Special Act would override over the General Act. So we have the provision, and there is a provision in the Article 20 also. So you cannot, there is no question of the double jeopardy. The act is altogether different, which falls under the Special Act. So you are not being prosecuted. And there are some provision also, the 300 CRPC, there are so many provisions, you cannot punish twice for the same offense. So we should not carry this kind of the confusion. This is my point, that's all.
Thank you so much. There are two more questions. Before I bring them in and I take them specifically to, there is a question from Zini Mehta, and we take this to Vaibhav and Mr. Sharma. She says, she makes a point and then she asks the question, PMLA should be a complete code in itself, and provisions of the Code of Criminal Procedure 1973 to as of 1974 as to arrest, search and seizure, attachment and confiscation, investigation, prosecution shall not be made applicable, as PMLA is a special law. Do you think PMLA should be amended? First to Mr. Sharma and then to Mr. Gaggar. Mr. Sharma, you'll have to unmute yourself.
Thank you. As Justice Gupta just pointed out, there are separate provisions and both the provisions can go simultaneously until and unless the law is, until and unless it is barred by statute, they can go simultaneously and they deal with separate situations. The PMLA Act deals with the situation subsequent to the commission of the crime. And while the Indian Penal Code deals with altogether different situation when the offense is being committed. Therefore, to say that there should be amendments in PMLA Act is not required. It's a perfect legislation, and it's a legislation which is there for the society, for the benefit of the society, to take away the arguments of the accused after they commit the offense. That look, we are ready to settle the matter. We don't need them to settle the matter. Do not commit the offense is what is required in this society as of now. Thank you.
Thank you so much. Mr. Sharma, I want to ask you a follow-up question. You know, as we discussed that there are loopholes in this and how these criminals exploit them. Give us a quick, input on these loopholes and how do you think they can be plugged in the future? A quick one.
See, the loopholes, how the loopholes are there. Loopholes are there in every law. The moment they commit a crime, we come with a solution to it. But here the question, the basic point remains is the reporting has to be expedited. There should be immediate reporting of the offense. In India, what happens is we have layered, as I just stated, there are layers and layers of agencies which have to be consulted before a complaint is filed to the CBI. In the meantime, everything is lost, as Justice Gupta just pointed out. Now, what we have to ensure is that without going to any other agency, straight away, the complaint should be made immediately to the investigating agency, and it should be taken as an offense if you do not make an immediate complaint. They should not be permitted to conduct financial audit, because here in financial audit, they want to take a few more years. They want to take away a few of them, and as it is, we are going to conduct our own financial audit. So if few years are taken in their financial audit, again a few years are wasted. Then what is most important is it is pending before Supreme Court. Whether 17A should remain there or not, the matter is pending before Supreme Court. So let us wait. If 17A is declared ultra vires, if it is declared unconstitutional, then the matter would end. It is not only this. There's another provision. Look, let us see. In NCB, in other agencies, Enforcement Directorate, and even NIA, they do not need to take consent from the state before conducting investigation in an offense which is committed in the state. But the CBI, as per the provision of Section 5 of DSPE Act, has to take permission. Now they have withdrawn the general consent, and now if it go to the state for consent, they will not give it to us. So what happens is, in this fight, then we'll have to approach the court. The victim has to approach the court to get the matter investigated by CBI. So except for CBI, all other national agencies, they can directly register an FIR, they can directly investigate, but not us. So there are layers, at least for the CBI, there are layers and layers of things which have to be complied with before registration of an FIR. So even we have to simplify for LRs as well. The procedure which we adopt now, it takes years to get documents, simple documents from other countries. So until and unless, and also one more most important thing, during the investigation investigation, we find at least 200 persons, as I just pointed out, are absconding as of now, they're abroad. Now, if we have provisions for retaining them, the minimum restraint is by way of LOC. And even if we continue to have LOCs in every case, in that situation, at least they submit them to the investigation and then they'll not run away. If one accused runs away in a case, if there are 200 cases, if one accused in every case runs away, almost all the cases come to a standstill. And then we say that the matter has been delayed.
Thank you so much.
One more thing, yeah. Multiple applications would be filed during investigation and during trial as well.
Thank you so much. Nilesh Deep's question was on similar lines. He says, since we are seeing emergence in banking fraud, if sanctions for prosecution against public officers, bankers are declined, can the CBI court still proceed under provision of IPC against those public officials, even though the public officials are exonerated in internal departmental proceedings? Mr. Sharma, question to you.
Yes. This is a settled law once again. Department proceedings have got nothing to do with the criminal proceeding until and unless the departmental proceedings the criminal proceedings have been initiated on the basis of the departmental proceedings. So just exoneration of an accused in a departmental proceedings would not have its effect in continuing with the criminal process against an accused. Now left with the other aspect, I don't remember. There were two parts of the question.
Yeah, basically he's saying that would they need, and because they are exonerated from interdepartmental.
That I've already answered. Thank you.
Yes, yeah. So now let me bring in Vaibhav and then Justice Mukta Gupta. Vaibhav, Lalit Joshi is asking, should there not be a time dimension for the conclusion of legal action based on well-estimated facts on the aspects of wrongdoing or criminality and financial sums? Secondly, how does a citizen fight single-handedly, whereas his wrongdoers are organized gangs and sometimes acting in collusion with authorities and politicians? I know it's a little philosophical question, that's why I asked you.
So let me take it one at a time, Dr. Batra. Number one, of course, it would be ideal to have time-bound disposal for both investigation and for the cases to be decided. But as the saying goes, if wishes were horses, beggars would fly. In India, we have a serious strain on our resources. We have a massive strain on the number of cases. Today, ED has all of 400 investigators. And ED is probably doing the maximum amount of investigations. Do you know there are 13 law enforcement agencies in India, 6 intelligence agencies, 8 regulatory authorities that conduct investigations as well, and 4 international agencies that they have to coordinate with. What are we talking about? Of course, it must be time bound. But how do you make it time bound is a question that we need to ask ourselves over here. I also want to bring about one very important thing which came about in the discussion earlier. And I think that has the only way you can actually make things time bound is please bring about the whistleblower protection, because I do a lot of what is called antitrust competition work where the whistleblower regime is very strong, right, globally. And it's been there in the US since 1897, etc. And the cases move very expeditiously, even in crimes, because their cartelization is a criminal offense for life imprisonment. In India, we've not put cartelization as a criminal offense. But just take a cue from there. With a robust whistleblower policy, 8 out of 10 cases finish within a time period of 6 to 8 months globally. In India, we are still getting there, and the whistleblower matters are finishing at least within a period of 2 years, which is far better than any other investigation that we can talk about in India. And these are financial crimes. Again, they've not been made criminal, but it's the same thing. In fact, the impact is at a macro level and not at just a micro level when it comes to antitrust issues. So 1, whistleblower. 2, I believe, as Mr. Dubey had pointed out, please allow compounding of offenses, because you achieve 3-4 tasks immediately. You lessen the burden on the system. B, the person has to not just put back the money, he's got to double put back the money, right? So he's pretty much wiped out.
C, he will always remain castigated. D, he will remain in the eyes of the law. E, the entire process actually gets expedited significantly. So if you are able to bring these two things in, I believe it is going to lead to a massive difference in expeditious disposal of cases. Apart from that, I need to point one more thing out. Last year, the Financial Intelligence Unit was brought about under the Ministry of Finance. This is a unit which actually coordinates with the banks, financial institutions, and all the 13 agencies that I mentioned about. So centralization has finally been brought in. If they are actually empowered and they are given the right technology, big data crunching, for instance, last year, 530,000 cases of STR, that is, were reported to the FIU, 530,000 cases, right? Which they had to churn out to these agencies. And STRs are suspicious transactions, just for your information, right? If you bring in big data, artificial intelligence within this, you are going to be able to crack this in much better time. No matter how many people you put there, the finest brains you put there, they cannot possibly do what artificial intelligence and big data crunching can do. Then it can be expeditiously put on to the various agencies, and you can also ensure there is no overlap because it is being done in a definitive manner. So steps are being taken. There are solutions. There needs to be more foresight and expeditious disposal then can be possible. Otherwise, we are living in a little bit of a la-la land here.
Thank you so much. We're at 1:05, and I'm conscious of the time. Time is the biggest asset we have, apart from our health. When I was younger, possibly 12 years old, my mother would tell me the only two things that matter are time and health. I think it's very late in life, I started to realize the importance of those words. So I'll ask Justice Mukta Gupta for her closing comment and also response to the earlier questions if she can.
Thank you, Mr. Batra. I would concur with Mr. Gaggar that time-bound investigation and trial is a need of the hour. But as I pointed out, the problem is the detection to find out that the offense is committed, because ultimately to unearth that actually an offense is committed at times takes a lot of time. And then we don't have the trainings to we don't have those specialized training. The manpower we are deficient in manpower at every stage. Despite the fact we've created number of agencies, each having its own specialized way of investigation. But we hardly know in every system there are a few hands who are good at investigation. With the result, they get overloaded, and the result is that they are not able to deal with all the investigations. He has a point when he says, yes, Mr. Anupam Sharma said that the punishment should be higher. But after all, these are all financial crimes. If the penalty is manifold, that itself acts as a deterrent. Now, making the penalty very, very high and then getting it deposited immediately will have a better deterrent so that he does not repeat. Now, what happens in all these NPA accounts, which the big names we all discussed, after all, these were all NPA accounts. What prosecutions we are doing is because they gave wrong statements, so this offense is made out. They made this alteration in their companies, audit reports, etc. So these offenses are made out. Ultimately, while doing that, there may be sometimes a genuine reason. Today, let's all see, we're all facing pandemic. Now, many companies which were doing very nicely will be facing problems that they can't return their loans. Of course, moratoriums, etc. have been extended by the orders of the Supreme Court, but what if their businesses don't revive? So what should be the way forward? We'll have to consider all these issues and then apply the special enactments and see how to work it out. So compounding and penalty would be a big step forward to encourage people to come forward. And I believe in most of these enactments, like the income tax, they have their own unit that this particular category of offenses you can go before the settlement commission, and then you have to disclose everything. You can't just go to the settlement commission without disclosing the facts. So PMLA also we have penalty proceedings, prosecution, everything. So these all count for, these all have a deterrent effect. But some mechanism we have to ensure is that we need to know these offenses immediately with due dispatch. The moment we are able to expedite this procedure, I think everything else will fall in line.
Thank you so much. And Justice Gupta, we have the fortune of having your presence here. I want to ask you about, without taking the names, about the specific situation. Let's say there was a bank and the bank gave a loan to a certain industrialist, and then there was an independent director appointed on the board of the bank who pressed for recovery and were not involved in the earlier loan. But when a case was filed against the industrialist, the independent directors who actually opposed the loan were not involved in sanctioning the loan, were named in a charge sheet against them when they were not involved. And later on department inquiry, the bankers who actually sanctioned the loan were exonerated, whereas the people who were falsely implicated still continue to be in that, and neither is the evidence taken. So in these, how does one deal with I'm taking a specific case that I'm aware of. How does one make sure that the innocent or the people who are actually opposing the grant of the loan or who are pushing for the recovery are not targeted, because the industrialist has possibly done some arrangement and has made sure that he and the people who are actually involved in the till have been absolved, but the people who are actually opposing have been put in the dock. So how does one deal with such situations?
See, Mr. Batra, I think that's why I say that the courts are probably trained to deal with all these situations. The investigating agency may have their own way, but that's why quashing petitions are entertained. During trials, they are discharged, they are acquitted. And that is why the directions that you must have the entire evidence, find out. Now, if a person is not even a director at the relevant time when the loan was taken or it was siphoned off, where is the question of fixing his liability? And let me tell you very frankly, with my little experience, whatever I have, this kind of charge sheets are not unknown. But then those people come to the courts and then remedial actions are taken. Whatever best relief can be granted, which is their right, which they should get, is granted. These are complexities. What happens is, now it's very easy, as Mr. Anupam Sharma said, they get acquitted. But then if there is no evidence against the person, he is entitled to be acquitted. We must understand that criminal law has its own fundamental principle that if you have not proved the offense beyond reasonable doubt, you cannot send him behind the bars. There is a difference between taking penalty from him, confiscating his proceed, but sending behind bar, it is his personal liberty, which is very paramount to be considered. Now, supposing all these aspects, you've given an example that the person was not even involved in the taking of sanction, he was not involved in how it was siphoned off, but still charge sheeted, and the actual person who was a mastermind has not been charge sheeted. Now, the courts, when they see it, that is why one of the major reasons that many of the cases get acquitted. It is not that the acquittals are passed without any reasons.
Okay, thank you for being that sane voice and being a sensitive voice. Let me ask Mr. Pramod Dubey, before I bring in Ms. Pinky Anand, what are your views on PMLA, Mr. Dubey, because you dealt, and what are your views on the whistleblower sentiment that Vaibhav brought in?
So far as the question regarding the amendment of the PMLA, which was asked by one of the viewers, I would say the PMLA itself has a complete code. There is a provision for search, seizure, arrest, penalty, compounding, or taking the cognizance. Everything is there. And there is also a provision, section 46. The 46 says that the code of the criminal procedure will be applicable. if you have the provision in the PMLA Act, you can go with the PMLA Act. If you don't have the provision for a particular act, then you can adopt CRPC as provided under Section 46. So I don't think you need that kind of amendment because you already have the provision under Section 46. So far as the whistleblower is concerned, the whistleblower, the Law Commission of India made the recommendation for the enactment of whistleblower in 2001, but nothing was happening. Ultimately, the Supreme Court of India passed the direction for the administrative machinery should be there, and then the resolution was passed by the government in 2004. And in between, you must have come across this incident of the whistleblower, NHIA engineer Satyendra Narayan Dubey. It was very known case those time. The whistleblower was there, and he basically brought the facts, the commission of the crime to the agency. Ultimately, he was killed, and there was no protection. So in 2014, the Whistleblower Act came into the force. They are in process of amending the Whistleblower Act. Again, the second Reform Act came. It was passed, but it is not passed by the Rajya Sabha, still pending. So you need Whistleblower Act to be very strong, because in white collar crime, especially white collar crime, you need a whistleblower. We have the Whistleblower Act that's protecting the public servant. We need the act to put for the protection of the employee who are in the private sector, the multinational. And you've already seen the ICICI matter. The Arvind Gupta was the whistleblower for this Chanda Kochar matter, the ICICI matter, the Infosys matter, the Wipro matter. So you need whistleblower. This is the demand of the day. So the legislators should come forward and bring this act to make this act so strong so that you can resolve so many matters pertaining to the white collar crimes. Because the person, the management is doing the act in a closed door, as pointed out by Mr. Anupam Sharma. Everything is being done in the closed door. So it is the whistleblower, the employee, and the person who are the best person. Still, we have the provision of the approvership in our CRPC. The person who has known to the offense, aware of the person, he can be done as the approver. But the Whistleblower Act will give the more strength to unearth the crime related to the this white collar crime. Thank you.
There are specific questions. I want to close the webinar. It's lunch time, and I'm sure all of you have to get back to work. And I want to start by asking Ms. Pinky Anand her closing remarks as we close this webinar. I think it's been a very nuanced and a fascinating conversation. Ms. Anand, your closing comments.
Annurag, I do find indeed that the discussion has opened up even more arenas of discussion. I think we're kind of re-looking at certain of the propositions. I mean, for example, new law versus existing old law, multiple agencies versus lesser approvals, the rights of the accused. So, these are the typical legal issues and academics that we discuss with and grapple with as lawyers and judges, trying to get a system which gives you the rule of law insofar as reparation to the people who have lost is concerned. But at the same time, you do have to look at what rights the accused has and to ensure that we do not make it into a scam of its own kind. So that balance is, I think, what is coming forth from all aspects. And you've really been able to put together that balance. And possibly the second feature that I can just outline on a larger platform is the interplay of various laws. Of course, the need to update laws as time goes, but that keeps happening because crime keeps changing its complexion. Once you get one crime, then you get on to another. I mean, that basically is a process like a snakes and ladders, which carries on. But the multiple layers of laws that we do have, we do need to put them together so that they are efficient and effective. There is no point in having number of laws at the same time not being able to effectuate them and to have the interplay of investigative agencies, which is a very important part of the function of law as it stands.
Thank you so much. Let me bring in Mr. Anupam Sharma for his closing comments. And Mr. Sharma, there is a specific question. We've got 10 odd questions, but I'm taking this. This is from Akash Chatterjee. He was asking, what if there are 180 accused? How do you deal with that? And he specifically said, like in the Bhushan Steel case.
We do not follow it, but separate trial is a rule. Joint trial is an exception. They can segregate trials. The trials can also be segregated in the manner, segregated in a manner like if the offenses which are committed, there are a set of offenses. Cheating is every act of misappropriation, every act of cheating is a separate offense. Now, what we do as investigating agency is we combine all of them and file a single charge sheet. And it is actually very tough for the prosecuting agency then to prosecute all of them 180 together and for the court to decide the cases of 180 persons together. In that situation, firstly, we have to identify whether it is the same offense or it is a case of multiple offenses. The multiple offenses, if it is a case of multiple, because cheating is normally never committed in one go. We might say that there is a fountainhead, and the fountainhead is that the conspiracy was to commit this offense, but that is one side of it. Each act of cheating, besides that fountainhead, would be whenever they commit an offense, it will be separate offense. Whenever they commit forgery, it will be separate. Let them be separate so that we'll have only a few accused in a particular case, and everybody then the trial would be expeditious. And there are few judges who go in this manner. They demand from the investigating agencies kindly separate the charge sheets, and those cases have gone up well.
Thank you so much. Clearly, and that was your specific response to a specific question. But your closing comments, as Ms. Pinky Anand said, that a lot of aspects have been discussed, but it opens up vistas for detailed discussions on each one of us. And we at BW Legal World would strive to do that in future. But your closing comment, Mr. Sharma.
I just like to close my comments dealing with only one aspect, that is compounding. The moment we say that these offenses should be compounding, aren't we treating them with a kid glove? On one side, we say that these are the offenses which are of the highest possible offenses. These are highest possible, most grievous offenses. And on the other side, we want that they should be compounded. One. Number two, a businessman wants money today. He'll commit forgery he'll commit forgery in order to take loan from a bank, in connivance with the bank officials, of course. Once he's taken the loan, thereafter the case would come up. It will come up for hearing at least after 10 to 12 years. This is normal. This is normal. I gave the reasons why it does happen that way. During that many years, he'll be using that money. One. Number two, it will lead to a situation where we are propagating commission of crime. The people would commit crime. They'll say, "Oh, we'll pay it later on. What difference does it make? Nothing is going to happen to us. We'll not go to jail." And it does happen. In how many cases do these criminals actually go inside? Initially, we do not arrest because it's a case which has voluminous record. We can't complete it in 3 months. All right. We want minimum restraint by the way of LOC. Then when this happens, subsequently when the case comes up, there are voluminous documents once again, because it's a high profile crime. Documents are involved. It has international ramifications. Witnesses from abroad has to come. And when the trial is concluded, it has taken 15-20 years. The compensation comes thereafter. The order of compensation is the last order. And that compensation order is against a person. Now, the defense counsels in the High Court, they're contesting that the state is not a person. Secondly, even during the appeal, when they file the appeal, this order of the compensation is automatically stayed. Now, the appeal would never come out during the lifetime of that person, and the appeal would abate. And the moment the appeal abates, thereafter the money would go. And regarding that is why they say that there should be compensation. But the basic argument is this is going to lead into commission of more crimes, spiraling of the crimes, which should not be permitted. We should have legislation which will be so stringent that they should not dare to commit offenses, rather than allowing them to propagate the commission of offenses. Thank you.
Yeah, so Mr. Anupam Sharma is making a very strong case for not compounding it, because that may act as a deterrent to do it. Mr. Gaggar, your final comments.
Let me just comment to what Mr. Sharma said, and I think he's got a very fair viewpoint on that. However, let me nuance compounding by saying actually plea bargaining, as is done globally across jurisdictions, across jurisprudences. If the person before the charge sheet stage comes and is willing to do a plea bargain, then X becomes the penalty. So if it's 100 crore fraud, 200 crore needs to be deposited. If it is between charge sheet and charge being framed, it becomes a different level penalty. If it is at the final stage,
after charge, before conviction, finally after conviction, it's a different level. Just as an example, antitrust laws again, 10% of your global turnover can be a penalty imposed on a company, sir. That kind could shatter the living daylights out of companies. You can have very, very stringent penalties. Maybe compounding needs to be nuanced by saying plea bargaining. And yes, compounding should not be taken as a way to incentivize someone committing a fraud. So plea bargaining with thought out measures can actually be a boon and not a bane. Thank you.
Thank you so much. Mr. Pramod Dubey, your final comment before I come to Justice Mukta Gupta for her summary and her final comment. As she's a sitting judge, we let her preside over this and close this.
What Mr. Sharma's view is there. Mr. Sharma's view is only the helplessness on the part of the investigating agency. We are living in a civilized society, so we have to see the interest of the accused also. And I've been practicing in the defense side, so we have seen more on the side of the defense, though I've been public prosecutor in some matters. And what has been suggested by Mr. Gaggar, we have the judgment of the Supreme Court in Negotiable Instrument Act as proposed. The stages are already there in the judgment. So legislature can bring the act, make the amendment in the plea bargaining provision in view of the Supreme Court judgment. So this can be done, and I would rather go with the compounding at the earliest stage. The plea bargaining should be made stronger and stronger. The quantum of the penalty should be increased, and we have to, in a criminal law and the criminal jurisprudence, again I'm reiterating, the enactment of the several law is not the solution. The enforcement of those laws is very important. So you have to make your investigating agency, your prosecuting agency more stronger and more stronger, and give all the resources which are the demand of the days in this computer era, this software, because we have seen a lot of the crimes are being committed. There's the cyber crime, and we are helpless. We don't have a strong cyber team even in city like Delhi or Bombay. So you have to make your entire agency stronger and stronger to control this kind of the crime. Thank you so much.
Thank you, Mr. Dubey. As I said, it's customary to end with Justice Mukta Gupta. We let her have the final word and call this discussion and conversation closed. Justice Mukta Gupta, your final words.
Thank you, Mr. Batra. It has been a very informative discussion with such illustrious speaker, and on the white collar crime, how it evolved, and thereafter the various nuances of it, the various aspects, how one particular agency feels strongly about it, the others feel in a different manner. Let me clarify, when we say that we should go for compounding and plea bargaining, it cannot be in all the offenses. That is why the classification of offenses has to be there. When you have a classification of offenses that till this category, you can compound or plea bargain, and this will be the penalty, which has such a deterrent effect that he knows that if I have to immediately pay 100%, 200%, 300% penalty, then the business will be finished. Instead of that delayed long trial where he will never undergo a sentence, by the time his trial is concluded with that 10,000 pages charge sheet, which investigation takes 1 year, then 10 to 15 years trial, then another 10 years appeal. He knows that within 3 months, if I am found that there is something made out like this, I have to pay 300, 400% penalty, and I will not be in a position to play, and all my assets will be then attached. It will certainly have a deterrent effect. Deterrent effect is not only by sending behind the bars, it is also, in fact, most of the time, this financial punitivity also has a lot of deterrent effect.
Yeah.
People, you will find many of the people will say, just send us behind the bar, we are not ready to pay the money. They are very, very willing to go. What will happen? You'll send them for 3 months, 1 year. What is ultimately, have you compensated the loss which has caused to the exchequer and to the people? What happens in all these matters is that it is the money of the common man. Bank has given loan. Now forgery is committed. Of course, if he commits forgery, he will be convicted for it. He will have to undergo sentence. But if within immediately that compounding plea bargaining has such a deterrent that it will impact the society, bring back to the society what has been lost from the society with penalties, I think people will have a deterrent or not. And it is not in all kinds of cases that you can across have. There is always like plea bargaining provision itself in CRPC. It says up to a particular 7 years, not beyond that, offenses. So we can categorize the kind of offenses where we should have this plea bargaining provisions. And as we said, there are multiple agencies investigating. There are multiple offenses, but the fact remains is that yes, for each offense, the ingredients are to be seen. Sometimes there is an overlap, but the ingredients, if you go by the definition of each offense, is different when it's a general offense and a specialized offense. And wherever it falls into it, then if it's a specialized offense, the person is convicted for the specialized offense. Like today, if he's charged for 2 offenses, one is general and specialized offense, and end of the day, the court says that since he's been convicted for the specialized offense, that serves the purpose. Sorry. So all these things have to be gone into, and we need to, with the enormity of the task with us, both at the stage of investigation, trial, and then appeal, we need to find out solutions to work. And without that, it will be all paper laws, which will not have meaning to the general public, to the society, to the accused, to the offender, everybody.
Thank you so much.
Thank you very much.
I'd like to end by saying, one, you've given more time than we had requested you. So gratitude to Ms. Pinky Anand. Your being here added serious content and gravitas. We look forward to more discussion. So on behalf of Anisha, me, and Krishnendra, and Garima, who's backstage, gratitude to all of my panelists, all our audience who joined us on Zoom, LinkedIn, Facebook, Twitter, Instagram, to watch this very, very detailed discussion. I think, as Pinky ji rightly said, there is a scope for getting nuanced and look at all the dimensions in a very individual way. And hopefully we at BW Legal World will do that. Those of you who missed today's conversation, watch it on the YouTube channel of BW Businessworld or the YouTube channel of bwlegalworld.com. Read it on Monday on the BW Legal World site, or simply read the BW Legal World inaugural print issue that comes out in July. Thank you so much. We're grateful to you, Ms. Pinky Anand, Justice Mukta Gupta, Mr. Anupam Sharma, Mr. Pramod Dubey, and Mr. Vaibhav Gaggar. We wish you luck, and I'm sure with the inputs that you have given to us and our viewers, I'm sure as we move forward, the issue of white-collar crimes gets the right framework so that it is minimized as well as ongoing litigation is solved and provides justice. Thank you so much. God bless you. Good afternoon. Have a great weekend.
Thank you.